Hi guys, welcome back. Last week we talked about how I disputed NASA's version of the undisputed facts that they presented in their motion for summary judgment. Now, I'm not an attorney and I was learning on the fly when I was going through that process, so I treated pretty much everything like it was a factual dispute. They say this is the fact, I don't think so, and here's the evidence that proves my side. I prevailed on summary judgment, so what I did must have been good enough. And if all you're doing is writing down your disputes for your attorney, well, that approach should work well for you too. Your attorney is going to know how to frame your disputes, and they're going to be able to bring in case law that supports you. But if you don't have an attorney and you're trying to respond to your employer's motion for summary judgment all on your own, there's going to be some stuff you need to know that I didn't talk about last week. And in the comments last week, one of you who is pro se reminded me of this by asking a simple question. What if the undisputed facts our employer includes in their motion are actually true, but just not relevant? So this week I went looking for an answer to that question, and I discovered that there are other types of genuine disputes of material fact that we can raise to defeat our employer's motion. And today I'm going to share what I found so that you guys can do an even better job of responding to your employer's motion than I did. I have to say that if you're pro se, today's video still isn't going to be everything you need to know about motions for summary judgment, but it should give you a more complete understanding of what your options are. Motions for summary judgment are usually filed after discovery is complete, but before our hearing is scheduled. And the rationale put forth in these motions is fairly simple. All the important facts of the case are in, both sides agree on what they are, and those facts only support one case, ours. So we don't need to bother with a hearing, just go ahead and give us the win now. And often judges do that. If you're at a point in the process where a motion for summary judgment might be coming, it's probably a good idea to familiarize yourself with Rule 56 of the Federal Rules of Civil Procedure. They lay out all the rules for what we have to do, what our employer has to do, and what the judge has to do during summary judgment. And most of the genuine disputes of material fact that we're going to raise trace back to this rule. I'll leave a link in the description so you guys can find it and read Rule 56 for yourselves. It's less than a page long and fairly easy to follow. Now, Rule 56 Part A says the court shall grant summary judgment if the party who submitted the motion for it, in this case our employer, shows there's no genuine dispute as to any material fact, and those facts show they should prevail as a matter of law. And if they can't show that, summary judgment isn't appropriate. Rule 56 Part C says that while we're arguing over summary judgment, both we and our employer have to cite specific evidence from the record to support our position. And Part 56C also says we can defeat a motion for summary judgment by showing that the evidence the other side is using doesn't necessarily mean there's no genuine dispute of material fact around it. And that's the part of Rule 56 that's key to disputing the stuff that's not relevant. Basically, we're trying to show that even if all the facts our employer cited in their motion are true, that still doesn't mean there was no discrimination. Unfortunately, I can't give you an example of how I challenged the relevance of the facts that NASA provided in their motion for summary judgment because they didn't put a lot of irrelevant stuff in their motion. But I can give you an example of how I challenged the relevance of their evidence at a different point in my hearing process, and that'll give you some insight about how to go about it. NASA's list of proposed witnesses included a close personal friend of my boss, who wasn't in my chain of command and hadn't witnessed any of the discrimination I was alleging. NASA planned to have him testify about several occasions when he'd seen me leaving the building in the middle of the workday. He'd recorded dates and times, and NASA said that proved that I was an employee who couldn't be trusted to telework. Now, I couldn't dispute all those dates and times because some of them were actually factual, but I did dispute the relevance of his testimony because often I had to leave the building in the middle of the day to go to meetings in other buildings or to visit the labs or any one of a dozen legitimate excuses that I had for doing it. And since he wasn't my supervisor and wasn't even in my chain of command, he couldn't possibly have known when I was authorized to leave and when I wasn't. So even if all those dates and times were correct, they didn't prove anything that was material to my claim. My AJ agreed with my logic, and my boss's friend wasn't allowed to testify at my hearing. And the same thing happened earlier in the process when NASA tried to convince my investigator to interview that same guy and get a statement from him. She found his testimony wasn't relevant either, for the same reasons. And of course, to be able to dispute relevance and make it stick, we have to know what's material to our claims and what isn't. We have to know those central questions that cut to the heart of our case. Knowing the prima facie elements for each of our claims and knowing the legal standards that apply to our claims is a good start. And in the description, I'll put some links to that information for some common types of discrimination complaints. Now, there are a couple of other types of disputes we can raise in response to our employer's motion, and next week we're going to talk about a couple of those. And the week after that, I want to talk about how we frame these arguments, and I want to share some very basic case law that we can use to help us out here. So we're going to be talking about summary judgment for a while. You guys don't want to miss that, so click the notification bell below, and I'll see you next time. Till then, take care and hang in.